So for our group, we got a question too, which is Datin Salsa had invited Rara, the world famous singer, to perform at her daughter's wedding next month for a huge sum of money. She has just discovered that Rara has accepted an invitation to perform with the Malaysian Philharmonic Orchestra MPO for 2 nights immediately after the wedding. Datin Salsa is most unhappy with this situation, as she wants Rara to sing exclusively at the wedding. So the question is, please advise Datin Salsa of her rights. So according to the English law, injunction may be issued to prevent the violation of negative covenants. According to common law, a court would not often issue an injunction to prevent a defendant from acting in violation of a negative undertaking if doing so would force the performance of a contract that would otherwise be unenforceable in equity. Thank you. So the issue that we decide in this question is whether Datin Salsa can apply for an injunction to perform a negative agreement against Rara on preventing her from performing with MPO under Specific Relief Act 1950.
The injunction to perform a negative agreement are provided under Section 55 of Specific Relief Act, which could be interpreted that an injunction to perform a negative agreement can be obtained by an applicant in order to bar a person from doing any act that one agreed not to do in the contract if one fails to achieve specified performance that compels the person to perform the contract. To have this kind of injunction to be granted, it must be fulfilled that there have been 2 agreements entered by both parties in which an affirmative agreement to carry out the specified action, and a negative agreement, whether expressly or implicitly, neither to carry out the specified action. Secondly, the negative provision ought to be severable via the remainder of most of the agreement. Lastly, it is seen that the applicant has fulfilled all of his obligation under the agreement. In applying to the situation whereby Rora accepting invitation to perform at MPOs after Datin Salsa's daughter wedding would constitute that there is an affirmative agreement that has been done. Meanwhile, the negative agreement shown in the situation from the question could be seen that Datin Salsa asked Rora to sing exclusively at her daughter's wedding implicitly. Consequently, the court may not be able to restrain Rora from performing at MPO, as there will be no cause of action to do so. But the court may allow Datin Salsa for an injunction to perform negative agreement by virtue of Section 55 under Specific Relief Act. Thus, it could be referred from the case of Pertama Cabaret Nightclub, Sendirian Berhad against Roman Tam, whereby the court held that the specific performance cannot be granted as the agreement that the respondent was to appear and sing in the appellant's nightclub, as this agreement relied on the personal volition of the respondent. However, an injunction to prevent the respondent from singing at other places can be granted by virtue under Section 55 of Specific Relief Act.
The next case that we could refer to is Digicel, Fiji Limited and Fiji Rugby Union, and another in 2017. In this case, the agreements between the parties has a negative covenant in which the defendant is restricted from contracting with third party regarding sponsorship. The defendant had breached such agreement and the court enforced interlocutory injunction in favor of the plaintiff. It is also mentioned that once the party had agreed to sign the agreement, it is enough proof to bind the defendant to a negative covenant. Applying the case of Digicel to our instant case, Datin Salsa would be entitled for a grant of injunction as Rora is bound to the negative agreement, which impliedly asked for Rora to not perform at other event following the wedding. Next, we will look at the case of Priyanka Shipping Limited and Glory Bulk Carriers Limited, a 2019 case. It is considered an evident breach of negative agreement when the defendant proceed to settle fixtures on the vessel when the negative covenant did mention that the only purpose for sale of the vessel is to demolish it and not anything else. Similarly, in our case of Datin Salsa, it is an evident breach committed by Rora to perform at others' event after having performed at Datin Salsa's daughter's wedding, as it is an implied agreement to not do so.
Next, I will explain another 2 cases that we use in this situation. The first one is Ribi children in the year of 2011. 2 young children were in the care of foster parents who had decided they wish to adopt them. The foster parents do not fulfill the requirement and the court granted interim injunction to prevent local authority from removing the children from the care of the foster parents. The issue is here was whether foster parents have permission to adopt the children within the period of notice. In the held of this case, therefore the interim injunction served to prevent the removal of the children for a period, allowing the foster parent to give the required notice, and thereafter a judgment would be made regarding whether the children should be adopted by the foster parent or whether the local authority should be able to remove them and place them in the care of alternative adopters. Based on the case of Pimpton versus Spiller, plaintiff had been using and had won action against another defendant. The judge here, which is Jessel, awarded an interim injunction, the plaintiff undertaking to abide by such order, if any, as to damages as the court may think fit to make it should ultimately turn out to be in the wrong. Therefore, the application we use here is the injunction is granted where a failure to do so would effectively close off one of the option letter to be executed upon. However, an interim injunction may be applied for in order to require RORA to continue on an interim basis, because otherwise agreement would be withdrawn and RORA would face loss before the matter could be executed properly. Plus, this interim is served to prevent RORA from singing an MPO after wedding of Datin Sasa's daughter, and allowing Datin Sasa to give required time, and thereafter a judgment could be made regarding whether RORA can be restrained by singing an MPO or whether Datin Sasa could order injunction for negative agreement. Next, I will explain another case, which is Bumi Amanda Navigation Sdn Bhd versus Mirza Marine Sdn Bhd. The fact is here, plaintiff signed agreement with defendant. However, defendant did not make a payment to the plaintiff and said that the ship did not fulfill the principal objective of the charter party. The issue is here whether plaintiff could seek Maneva injunction against defendant. The court held the plaintiff attempted to get Maneva injunction from the court pending the arbitral proceeding. The application that will apply to the Datin Sasa situation, Datin Sasa cannot restrain or order a freezing injunction to RORA from performing an MPO, because RORA does not breach her contract with Datin Sasa. However, Datin Sasa can apply for injunction of negative agreement between both parties. Otherwise, if Datin Sasa insists in claiming injunction and RORA succeed in the proceeding, RORA may enforce Datin Sasa undertaking to pay damages for her loss which arises from interim injunction pending the proceeding. Plus, in the situation in deciding whether the grant to order of Maneva injunction, court discussed a few elements to be fulfilled which clearly stated that Datin Sasa did not fulfill the elements. Therefore, she can only apply for the injunction of negative agreement. Thank you.
In the article Repudiation of the Doctrine of Automatic Termination in a Contract of Employment by Sir Muhammad Akram, referring to the case of Dato' Abdullah bin Ahmad and Syarikat Pemodalan Kebangsaan Berhad, when one party had accepted to perform a certain act and there is no express provision in the agreement stating that the party is not allowed to do a certain act, he or she is still bound to not perform the act, which can be a negative covenant to the agreement, which will be an implied provision. If we apply this principle in Datin Sasa's situation, RORA is still bound to not breach the implied negative covenant, even though it is not expressed, as the law allows such application, as well as illustration C under Section 55 of the Specific Relief Act 1950. Moving on, by looking at the article entitled Enforcement of Affirmative Covenants in Personal Service Contracts by Prohibitory Injunction, the author relied on the case of Webster and Dillon, where negative covenant is said to be implied when a performer agreed to perform for a definite period and the implied term is that she cannot perform somewhere else following the performance. Applying this authority to our present situation, it means that once RORA had agreed with Datin Sasa to perform at the daughter's wedding, her action of performing subsequent the wedding at a different venue cannot be justified.
In conclusion, Datin Salsa can apply for an injunction to perform negative agreement against Rora to prevent her from performing for Malaysian Philharmonic Orchestra (MPO) when Rora had reached the first agreement with Datin Salsa to perform for Datin Salsa exclusively. But Rora accepted the second agreement to perform for Malaysian Philharmonic Orchestra. This can be proved by looking into the Section 55 of the Specific Relief Act 1950, which permits Datin Salsa to apply an injunction to perform negative agreement to bar Rora from performing for MPO when Rora fails to perform exclusively for Datin Salsa. This can also be proved by analysing the 4 cases that as stated before, which requires the applicant to apply the injunction to perform negative agreement when defendant had breached the first agreement but instead accepting the second agreement. Itu saja.